Just to follow up quickly on Justice Kavanaugh's question about the finger pointing and the kinds of questions that the United States would be asked, it's my understanding in the United States brief that it said that it could assert the state secrets privilege and reserve the right to do so, although it had not yet in this case, right?
That's correct.
So if there was confidential information, there would be, you would agree, some sort of protection.
100%. And the reason why, and the fact that there are other mechanisms to protect the government's interests like that, undercuts the need to displace state law with federal common law in this case.
Justice Jackson?
And is it your view that really the rule that you want us to adopt, or the one that you're focused on, is applicable in the situation in which the contractor acts contrary to the military's interests because it's doing something negligently, that it has not been authorized by the military to behave in this way, the particular way that is being claimed as causing the injury in this case?
That's correct. I mean, if we're creating a federal rule to further the government's interests, the violations have to be factored in too.
How do we think about the fact that apparently DOD and its regulations left open the opportunity or said to contractors that you could be held liable? So it's the government's understanding that there's some operation of common law potentially against contractors in this universe, right?
That's huge, Your Honor. I mean, the fact that DOD has been telling contractors that they could be liable and that the public policy rationale of Boyle will not protect you if the government's decisions are not at issue, that's huge. And we also have the fact that Congress has not acted to displace state law here.
And with respect to the FTCA and the combatant activities, in your exchange with Justice Thomas, I guess I'm also curious about the point that I think Justice Barrett made earlier, which is that the combatant activities exception doesn't apply to contractors, correct?
Not at all.
So Congress did not envision a world necessarily in which contractors would not be held liable for these kinds of things.
Not at all. And that Congress doubled down in the Westfall Act when it passed Westfall Act to protect federal officials from lawsuits. It adopted the definition of the FTCA, which is the same, excluding contractors.
And finally, let's say if we think Padilla is the correct test, should we vacate and remand for further proceedings under that test? That was not what was applied here, correct?
No, but you should not, there's no need to, Your Honor, because we made arguments about why our position is correct under the Padilla test. It has not been disputed that Fluor could somehow meet that test here. And that is not the case because they violated whatever the military authorized and directed in this case.
Thank you.